And today we're talking about foreign buyers and the foreign buyer ban.
Yeah, interesting topic. So we'll be going through like how the ban came into place, how it's been extended now. We're going to go through the exceptions. We're going to go through like who temporary workers, students that are exempted, and how they can buy. What to be careful of when you're advising people who if you're not sure that they can buy under the foreign buyer ban or not. Even if you're sure how to respond to inquiries, next steps when you have potential foreign buyers, we're going to discuss all of that. That's a really interesting topic, a lot to discuss about.
I used to get inquiries on foreign buyer ban daily, if not hourly. Now, I would tell you I'm lucky once every 2 weeks, maybe somebody has a passing question. So it's there. It's not that it's not a hot topic. It's just kind of people have kind of put it out of their heads for some reason, for a lot part. But that's not necessarily the best thing on the planet because there are these exemptions. There is the ability still to buy if you meet an exemption. And if you do fit the criteria and you are a foreign buyer and you still got to pay the foreign buyer tax, if you meet the timelines and everything, you can get it back. So for some foreign buyers, there are opportunities, and not to just tell them, hey, it's banned, don't bother, the end, because there are ways around it if they do meet the qualifications.
So for those of you who don't know, apart from real estate, we also do corporate, commercial, wills and estates. So if your clients need assistance with those areas, we are here to help.
Good news, I've noticed at least since September, a lot of inquiries for wills and power of attorneys. People are thinking about the holidays in December, New Year's January, and are starting to plan their wills and power of attorneys. Also getting a lot of inquiries on corporate commercial items. So people buying businesses, selling businesses, commercial real estate, leases. So there's a lot of requests for them right now. And to me, that's a good indication if people want to do business, so to speak, that means that the economy is not in a bad place. So I see a lot of opportunities there as well for people who are in corporate commercial to know that there is a lot of demand.
Physical offices. So talking about real estate, we do, I would say 99% of real estate transactions completely virtually. We have physical offices if clients need to come in person. We have locations for that as well. Our social media handles, so please feel free to connect with us. We post regularly about real estate, outside of real estate. A lot of good information regularly.
And the thing to mention about the papers virtual, we've mentioned before, but for people who are new to it, the clients could be anywhere in the world. We could be anywhere in the world, and we can sign them up. We can close any deal in Ontario, so they don't need a Hamilton lawyer. They don't need an Ottawa lawyer. We can handle everything for them. And for some reason, a lot of people, when they buy and sell, want to be on vacation. So they go on vacation. As long as they have an internet connection, a phone, a tablet, we can sign them up the same way as if they were here. So very advantageous. 99% of builders accept our signed documents. Lenders as well, because we don't use DocuSign. We use a format where they hand sign, hand initial everything. So we would be, let's say, like on the computer here, text the link to the client. Client pulls it up on their phone. I have it on my phone. And every time it's prompted, they go on the screen and they draw out their signatures and initials. So really great, the same way they would as if it was on a paper copy. So life makes it very easy. So for clients that, you know, they're on the road a lot, they have young kids, whatever their situation is, they don't always want to jump in a car and have a meeting. We can do that. We can accommodate weekend appointments, evening appointments, same way kind of schedules you guys have. So just a note for future when clients are saying, you know, we have a closing coming up, but I'm really afraid. Do I have to sign up 3 weeks in advance? Do I have to go to somebody's office? No, we usually sign up the clients 1 or 2 days before the actual closing date. Just because, I mean, some transactions we can do them in advance, but situations change and why have to go and re-sign the documents again? So for convenience, that's why we normally sign a day or two before. So a little bit about us.
Coming to the foreign buyer ban, just this slide talks about like how it was introduced, how it came into force, when it came into force. Initially, it was introduced just for 2 years. Now it's extended until January 1st, 2027. It was really frustrating initially, and we had the act for such a long time. We had the content, but a lot of actual rules were supposed to come in different regulations that weren't introduced until December 21st, 2022, only a few days before the act came into effect. So like it was a clear indication like how unprepared they were while they were introducing this, and once introduced, there was a lot of loopholes, a lot of questions, a lot of frustration among professionals, among foreign buyers. They introduced some amendments, which we're going to discuss today. How those amendments came to, what was introduced, we're going to discuss that. But again, in March, they changed those rules, those loopholes, and now we are where we are. We'll discuss about those exemptions. Amendments, did amend, the major amendment was allowing temporary workers to go ahead and purchase. So we're going to discuss about that today.
This thing I'm going to throw out, and for a lot of us that are doing new construction, people still have questions. Okay, I have this new construction agreement. It's going to close way advance of when the foreign buyer ban is supposed to end. And am I okay? Can I still buy as a foreign buyer? And what I let people know is, we let people know, as long as this foreign buyer ban's in place, from the builder developer point of view, as long as this is in place, regardless of what the closing date is on new construction, and we don't know if the ban will continue, it'll drop, they're going to work within these regulations. They can't go and say, well, you know what, we're going to let you buy because there's a good chance maybe the ban will be lifted or maybe it'll be changed. They have to fit it under the current regulations, simply because if they come to pass January 1st, 2027, it's the same criteria or even more strict, and they allow a foreign buyer to buy, they're going to be in big trouble, because everybody who touches this file and aids and abets somebody to buy as a foreign buyer can be facing big penalties and issues. So bottom line is, any interest in real estate, with its new construction, assignments, resale, fits under here.
So what about those who bought already, and this extension hasn't come into effect yet?
Well, the people that bought before the dates of when it was introduced, that got grandfathered past that certain date already, which now has been for the last couple of years, they're all, from that date on, they would not have bought if they were a foreign buyer. So for somebody who brings a really, really old agreement that was signed much before this came into play, they're still allowed, but they would have been grandfathered, but that's now shrinking and shrinking as those deals are closing.
So what's the driving factor behind this extension? Like, why is the government doing that? Is it working for them?
If you can please bring us our federal government and explain what the logic is of what I'd love to see it. I'd love to, please.
And next question online here. Question is, can the government coming into force next year modify or change this rule?
They absolutely. So let's just say hypothetically we have an election next year, and let's say hypothetically it's a whole new government, right? And they get a majority, and they say, you know what, we want to fix the economy and we want to do things differently. They can start wiping out things left, right, and center, including this. The issue I'm seeing, and I'm thinking ahead a little bit, the fact that it got extended, it's going to be in play for X amount of time. The longer something's in play, the harder it's going to be for them to wipe it out. But it all depends on what political climate it is and what pressures they have. But if I'm a betting man, I still think there's a chance that it will go away at some point, but we can't count on that. For now, we're going to have to assume that it's here, it's staying, it's not going anywhere, and just keep an eye on it. That's all. We have to work within it. But for a lot of people that are applying for a PR in the future, plan to be citizens, are working here, have the work permit, they will pay the foreign buyer tax and recollect it again after, if they fit the criteria. So this is not stopping everybody under the sun from not buying as a foreign buyer. So just to keep those in mind. But before going to sign an agreement purchase and sale with somebody who tells you, yeah, I'm a foreigner, making sure contact us first, let's see if they fit the criteria before we put any kind of pen to paper. Like, if it's clear they are not meeting any of the exemptions, we're done. Like, we have to make sure on those.
Another question we have online, can a citizen of Canada challenge this rule in the Court of Justice?
You mean like the people that claim that CRA is unlawfully collecting income tax and they refuse to pay income tax, and sure. Anybody can create a lawsuit theoretically and do it, but good luck.
Any other countries like Canada have this ban?
That's a good question.
No, none that I know of.
I've never heard, you know what's funny? I follow other countries and, well, I kind of, I've said in previous seminars, if you want to see what's going to happen in Ontario, go watch what BC does. Because BC creates all these wacky rules and basically messes up the rest of the country, and then every other province kind of follows them along. So this is where, like, for example, on the trust arrangement that CRA and federal government decided that they're going to start having to disclose, we knew that was going to happen because BC was doing that. As far as other countries go, you know, looking at like New Zealand, Australia, England, like the kind of countries you think would follow us, never seen that. To be to be truthful, if you think about it, when you're a country, you want to bring in people with money, with education. You want doctors, accountants, whatever it is, whatever kind of energy you want to bring into your country. A lot of countries want to have foreigners moving. I mean, you think about Canada. Canada was built on foreigners, right? Like, if we were not encouraging, immigration, think how many of us would not be sitting here in this room today or online, right? So it's just kind of funny that Canada is the most inclusive country, and yet they're telling people, yeah, you can move here, you just can't own property. I don't know. I still don't understand the logic, so I don't think any other countries have either, as far as I know. But that's a good question. It'd be interesting to see if they do. But no, not many people follow Canada's lead, I don't think.
Oh, no.
Actually, it's the other way. If you actually travel the United States and you talk about what's going on in Canada, it's very interesting to hear the American take on our country now.
So yeah, non-Canadians. So the Act bans, basically the Act says that non-Canadians are prohibited to purchase residential property. So non-Canadians are defined under the Act as these entities. So anybody who's not a Canadian citizen or a permanent resident or a registered Indian under the Indian Act, then they are considered to be a non-Canadian. So either you have to be a Canadian citizen, a permanent resident, or an Indian under the Indian Act. Okay? Foreign corporations that are not formed under the laws of Canada or a province, those corporations cannot proceed to purchase. So foreign corporations are also, so we do get a lot of questions. We do have some creative clients who say that, okay, what if I incorporate a corporation by through it? So if you get questions like this from a foreign buyer who say that I can circumvent the legislation, getting a corporation formed and then buying through it, if that corporation is controlled by a different foreign individual, then that corporation is also prohibited. And in the next slide, we'll see what control is, right?
I'm just going to bring one thing here, Yash, that I find that there's a lot of confusion about. So let's differentiate between purchases and sales and make it very clear we're talking about purchases right now, not about sales. So had inquiries, and it may sound silly, trivial when you think about it, but knowing the rules, but if you don't know, people saying, okay, so I have a client and they are a foreigner and they own property. So now based on this ban, are they gonna have to give up their property? Is the government gonna take over their property? So we talked about the grandfathering part of it. So somebody who's a foreigner that's owned property here for 20 years obviously are not fitting under this. But the example I'm going to give is you have, let's say, a Canadian citizen, permanent resident, and they're living in the US, okay? And they've been living there for a while. When they go to buy, it's very simple. They're a Canadian citizen, PR, right? That means that they're not a foreigner for these purposes because they're a Canadian citizen, PR, they can buy. They're not paying the foreign buyer tax because they're a Canadian citizen, PR, done. They're going to go sell. Yes, they are a Canadian citizen, PR, but they're not a Canadian for the purpose of taxes under Section 116. They've not been filing their taxes here. So that's where the differentiation comes up. So just because you hear somebody's purchasing, somebody's selling, remember foreign buyer ban, everything else not involving an existing property, existing person, we need to know what their status is from a tax perspective, regardless if they are a citizen or PR of Canada. So somebody who lives in England, Canadian citizen PR, been in England for 20 years, but yes, they're a Canadian citizen or Canadian permanent resident, they are going to fit, so they are allowed to buy, they're not going to pay the foreign buyer tax in that case. So that's where, again, very important to ask those right questions. Are you buying? Are you a seller? Are you a Canadian citizen, PR? If you're selling, are you a Canadian for tax purposes? So differentiate that.
So husband and wife, husband, PR, citizen, wife is not, then only one person can buy it?
So we are
If
good.
we
Yeah.
talk about the exemptions,
Okay,
Yeah.
there's a spousal exemption as well.
okay. good.
There is a spousal, with everything with spousals, generally, it's very important to know if they do fit the spousal definition, and also, is there any other parties involved? Because if you have husband, wife, and friend, then that's where they could create the issue, then you lose that spousal exemption. So it's very important to know how many people, what is everybody's status?
Right, so as I was mentioning, so control of a corporation, they define it under the Act. They have kept it very limited. If a foreigner owns 10% or more of voting rights, or like the ownership in a corporation, that's considered a foreign corporation, right? Even if you have the shareholders, directors, all are Canadian, but if it's in fact being controlled by a non-Canadian under the Act, that would be considered a foreign corporation. So if someone, let's say, a foreign buyer trying to circumvent the Act, they form a corporation here, they have a relative shareholder director, but they're the ones who are actually controlling, they're the ones sending money, the corporation receives that money is used to buy that property, that can be still considered a foreign corporation. So even if every shareholder, every director is a Canadian, but it's controlled by a foreigner, it would be considered a foreign corporation. So types of residential real estate. Any property that we usually refer to as residential, detached, semi-detached, condominiums, all of those will be considered as residential property. Commercial properties do not fall under this, but yes, if any residential components attached to it, that will be considered. So for example, there's a residential condominium on the first floor, and the second floor on the first floor there's a commercial unit, and that can still be considered a residential property. So for any properties that you have and you know, have a doubt about, you can always reach us out. We can look into it, let you know if it actually will be prohibited under the Act or not.
Just remember that maximum of 3 dwelling units. So that's very key.
Yes, if 3 dwelling units, if it's more than 3, then that would be that won't be considered prohibited under the Act. So there's some exclusions. So there's some areas called census metropolitan areas and census agglomerations.
Why don't you tell everybody the fun times you had figuring out what that meant?
Yes. So
This was a barrel of laughs for him.
when this first came out, we didn't actually, read through the definition, but that's like really hard to figure out about how to figure out the population of an area. We looked into it online. There was no resources, not much.
Because you think that the government in its wisdom would give us a map, right? And highlight and make color coding and list off, here are the areas that are allowed, here are the areas that are excluded, make life easy, right? No, they gave us this definition to work with.
Yeah.
Yeah.
And then we started receiving questions from foreign buyers. I still remember that this act was like really fresh, and we got a question from a foreign buyer who wanted to buy a recreational property like a cottage, which was in a really remote area, and they asked if they can buy or not. We tried to figure out whether it will fall under this area or not. We couldn't find any resources online, nothing there. So we actually got into touch with Statistics Canada, and because they're the ones who've been responsible for figuring out which area is this. They got back to, I gave them the exact postal code. They came back to us saying, okay, we think this falls under this area, but we can't
Can't give you advice.
Like, they were taking the laptop. I said, you Statistics Canada, like, don't you guys make the areas? Don't you guys define this? But we were actually able to get written confirmation that it actually did not fall into that area
From them?
from them. Yes.
Yeah, because you have to understand 2 parts there. You got to understand what is a recreational property for these definitions, and then what is the area and what falls under what. Exactly, yeah.
And the government is relying on you guys, law firms, closing the deals to ensure that this.
They haven't actually, like, in the act, it doesn't say, like, who's responsible for checking this, like, to making sure. It just says that anybody who helps the foreign buyer to purchase, they will be personally liable for up to $10,000 of fine. So like anybody, real estate agents, mortgage brokers, lawyers. So there's no like set criteria, like who who's responsible for making sure.
But keep in mind, we're registering under provincial system. So every single province has its own system of registration. So this is done provincially, but it's a rule that's federal. And so who's policing it? Because federal is not the one in charge of registration. You know, it was hilarious because when Ontario had upped their foreign buyer tax, right? They announced it, and within, what was it, a day to a week, that's when the foreign buyer ban came up, and we said, like, they must not be talking to each other, clearly. So that's where they put this fine and everything else in to put the fear, because I don't know who's policing it. I don't know who's checking for that.
So what happens if a buyer gets through and ends up buying and closing?
Oh, we'll get to that. It can be pretty bad, yes. Yeah, including getting their property sold on them and everything else. So they put a lot of big, scary penalties. I have not seen one case yet of a foreign buyer getting identified, the property being taken away from them, but I'm sure it's coming.
It's unbelievable. This is somebody that's willing to buy and pay property tax and.
Well, but we have to assume that they committed fraud, that they did say they were a Canadian citizen or PR, signed it under a declaration, and it got discovered after the fact. This is not the real estate agent and the mortgage broker and the lawyer all in cahoots saying, we'll help you cover this up, don't worry about it. I'd hope not, but somewhere along the line, there's a check and balance that somebody should be discovering it. Otherwise, if assuming they were great fraudsters, then the question is, how did it pass through, and then who's going to be responsible? But we haven't gotten there, fortunately, and maybe we never get there.
So are you aware of anybody being fined for committing this? Agents or service providers?
I have no knowledge of anything, Jim. No? You? Yes? Yeah, we know we just dig a hole in the sand. No, I'm joking. But if we have any kind of hint even, then that discussion is done and we're not going to be retained. Absolutely not.
Now, for like what we usually do and what you can do moving forward as well, when we obtain IDs of clients, we make sure we have either their PR cards or their like Canadian passports to make sure that they are actually Canadian citizens from residents. So that's a map of the areas that we were referring to. Of course, like we can't figure out from this map like what area the property falls into, whether it's under a CMA or a CA. What you can do moving forward is like if you get inquiries from clients that want to buy a recreational property outside of these areas. Now after, I think, CMHC or the government, they realize that that there's a lot of problem with clients, like buyers figuring this out. They have a tool on CMSC's website where you can enter the address and they will let you know if it's under a CMA or a CA. So you can use that, but again, that's an online tool. It says there that the accuracy of the tool is not guaranteed. So again, you can't take the liability of advising a client whether it will be under CMA or a CA. You can help your clients figuring it out from the tool, but make sure you qualify your advice saying that they should insure with Statistics Canada and it's actually outside of CMA or CA. Okay, you can help them, you can initially help them figuring out from that online tool, but they should, of course, go to Statistics Canada and make sure it doesn't fall under CMA or CA.
PM has a question, and it's a little bit of a loaded question. Do you think a fourplex is a commercial type? And I'm just going to throw out there, PM. It depends for what purposes we're talking about. So for these purposes, there's more than 3 units. It's one thing for the foreign buyer ban not being met, but there's a different set of criteria for property insurance, for title insurance, for purposes of the mortgage. Everybody's got their own definition of what they consider commercial. I know some consider a sixplex more under a sixplex, for example. So I would say when a person is looking to buy a multi-unit residential property, talk to your insurance company, talk to your lender, talk to the lawyer, see under each criteria what is considered commercial residential, because there's different costs and criteria for it.
So most of the big cities that you will hear of, Toronto, Vancouver, Montreal, any areas around them would most likely fall under a CMA or a CA. A property outside of these areas would be a very remote area with a lot less population. So yes, most of the major cities that you hear about, or most of the cities around the major cities, would most likely fall under the CMA or the CA. So exemptions. People who are not Canadian citizens or permanent residents, there are some exemptions. Starting with a spousal exemption. So if a spouse or a common law partner of someone who's not prohibited under the Act. So spouse of a Canadian citizen or a permanent resident, if they buy with their spouse or common law partner, then they're exempt. So if, let's say spouses, or the husband's Canadian citizen, wife is not, then they can still purchase together. So that won't be considered a foreign buyer. That's a spouse. And for this definition, common law partner is under a spouse. So even if they're common law partners, they can still proceed.
Usually for taxation purposes, they allow common law to be considered under the definition of spouse. The one key exemption to that is the actual ownership and sale of the property and having to have spousal consent. Otherwise, when it comes to land transfer tax, almost any taxation, they include common law spouse, relationship of permanency, so if they have a child together, so there's different criteria for that.
So temporary students here, temporary workers in Canada. We'll talk about the criteria in the next slides. Yes, they're exempt as well. Some further entities that's prescribed by regulations: refugees, refugee claimants, individuals fleeing international crisis, or accredited members of foreign missions. But if you have someone who's claiming to be under this provision, of course, speak with a lawyer, because we would also need to speak with an immigration lawyer as well because they'll need to ensure what their status in Canada is. Then we have to match with the foreign buyer ban whether that status falls under the exemption or not.
If they're an actual refugee or not, or they're labeling themselves as a refugee, we'd have to know if they're actually considered a refugee for Canada.
Right, so this one's for students. So any student who wants to purchase, that's the criteria that they need to fit in. It's for workers as well.
Good luck.
For workers as well, this criteria, like similar criteria were there, but they took that off when the amendments were introduced. But yes, for students, that's the criteria. They must have filed tax returns each of the 5 taxation years preceding the purchase, present in Canada for at least 244 days in each of the 5 years preceding the year of purchase. Purchase price does not exceed $500,000, and they shouldn't have purchased a property before while the provision was in effect. So they can't buy, they can only buy one property. They can claim this exemption just once.
And then they.
Property in Canada or buy property globally?
No, here in Canada.
So if they come and they fit the criteria and they buy a property, yes, and then obviously they can sell it, but then they can't buy another one during the lifetime of the ban.
Correct. Yes.
Yeah. The other one now for the workers part of it, it's funny. So as soon as everything went down the pipeline, I had a very well-known hockey agent call me up and said to me, because he's based in Michigan, and he says to me, "What is wrong with your country? I don't understand. It takes me so much to convince people with taxation and everything else to want to agree to move to Canada to play for a hockey team in Canada. And now you're telling me they can't own real estate? Like, how does that make sense?" This is when it first came down the pipeline. And I remember at the time, the Blue Jays signed a player for a pitcher, 5 years, $100 million, I think it was. So $20 million a year for 5 years. How does him going, let's say, to Forest Hill and buying a $10 million house, how does that affect anybody? You know, you think about it. You've attracted him, he's going to be paying taxation here, living here. But when the rules first came out, he would not have been able to buy at all. And then those kind of circumstances came up. Now, not everybody's obviously a baseball player making $100 million, but you think about it, what if a doctor comes here and comes to work for a clinic or a hospital, and they're told, oh, during this ban, you cannot own real estate at all. So they kind of relented on this part really, really quickly and made it easier, I would say, for foreign workers that are here for a good duration. I think that's what they were looking for.
Correct, yes. So the criteria that we saw for students, it was similar criteria for work permit holders. So you had to be like in Canada for 5 years, to 44 days out of 5 years, all those taxation, the tax filing criteria, they had to fit in those before they could buy. So after, as Jonathan mentioned, there was a lot of pushback on this particular exemption. And now it's, as long as a work permit holder has a proper work permit, which is valid for the next 6 months, they can still go ahead and purchase. Okay, a lot of times we get questions as to what is the time that we see the 6 months from, whether it's when they sign an agreement or whether it's the closing agreement, right? We have been in touch with CMHC, and it's the answer was like first time someone assumes liability under an agreement, basically when they sign an agreement. But again, I always usually tell agents that it's better to also ensure that also from the closing date, a work permit is valid for the next 6 months, just to be careful. Because as we mentioned, there's personal liability in this act. It's better to be careful because the act specifically doesn't state, the act specifically doesn't define the date of purchase. So it can be interpreted as whether as like the signing the agreement or the closing date. Right, so it's better to consider from the closing date for the work permit validity. Again, work permit holder can only buy just once while the provision is in effect. If they buy once, if they sell, they can't buy another one, or they can't hold two properties. Right. But yes, again, just to mention, while we're discussing about foreign buyer ban, we don't have to forget about the NRST. Even if a work permit holder or a student, even if they fit under that criteria, they go ahead and make a purchase, they would still have to pay the Ontario's NRST. That's a separate issue.
And for Jim, so January 1st, 2023. So you finding any clients out there that entered into new purchase agreements before January 1st, 2023, they're okay. But like I said, those ones are starting to close more and more, but there are some that are going to be closing 25, 26, so.
So definition of a purchase is the acquisition with or without conditions of a legal or equitable interest or a real right in residential property constitutes a purchase. So not only buying real estate, acquiring any kind of interest in real estate as a purchase. So even a foreign lender is prohibited from for giving a loan which is secured against real estate, or basically a private mortgage where the lender is a foreigner, because that would then be very easy to circumvent the act. Someone lends the money, gets registered on the mortgage, the borrower defaults, now there's foreclosure, power of state, that would be easy to circumvent. So any kind of interest in the property, but we'll talk about it. That doesn't mean that they can't rent property. They can of course rent property, because leasing a property is also an interest, but there are exemptions to this, which we'll talk about.
And a foreign buyer cannot enter into an agreement to buy by assignment in new construction for an agreement that was entered into before January 1st, 2023. So let's say you have a client, Jim finds somebody, and they want to assign their unit bought January 1st, 2022. The assignee, the new buyer, cannot be a foreign buyer and not fitting the criteria as of today and say, oh, well, I'm grandfathered under the old agreement. The original buyer was grandfathered, not the new buyer, because the date of the assignment agreement will be now, and so that's when that would be the validity of it. So you can't circumvent it that way by assignment of an old agreement.
And sorry, going back to the purpose of this ban was to slow down sales and make housing more affordable for Canadians?
So that the foreigners will not be snapping up all the inventory, because there's no inventory. And then by them not buying, there'll be so much inventory, and then everybody will be able to go and buy properties, and the values should be decreasing because foreigners were raising the prices so significantly, and we'd be in this magical utopia, which never happened.
We have a lot of inventory now.
We always had inventory.
And
that never changed. And
more than ever before. And it's been extended to 2027.
I have read, let's say, at least 50 articles on this subject matter by many, many people way above our pay grades, you know. And they're saying that this affected less than 1% of real estate. Really, this had zero effect on anything as far as affordability. It didn't meet its purpose, let's put it that way. That's what the end of the line is. And if nothing else, you think about it, if I was one of the provinces, I would rather not have this ban and be collecting all the foreign buyer tax, which people were paying. Yeah. So you're actually hurting the provinces. I don't know, we kind of went in circles on this. I don't know what ended up happening that this had any kind of effect, really.
Hey, I just want to go back to your spousal definition, common law. What if it's a mom and daughter? Mom's Canadian, daughter's Canadian, mom is not. Are they allowed to buy?
No, it's only for spouses and common law partners, so not for any other relation. So exceptions, what's not considered a purchase? So any interest that is acquired due to death, gift, separation or divorce, that's not considered a purchase. What this means that someone can gift a property to a foreigner, that won't be considered a purchase. If through a will, like if a Canadian citizen or permanent, they leave their real estate to, let's say, their grandson who is not a Canadian citizen or permanent resident, that won't be considered a purchase. So acquiring it through will, that won't be considered a purchase. Similarly, divorce or separation, that's again will not be considered purchase. Foreign buyers can still acquire property through these three.
I'm going to answer the Jim question right now. No, Jim, somebody cannot gift someone a property and then the other person just gifts them $1 million back. It doesn't work like that. It's not Christmas, New Year's gifts. If somebody gives somebody a property and receives back the gift of $1 million, that's that is consideration. Yeah. And I've been asked that multiple times, actually. People find all sorts of angles, they think. It has to be a true gift with nothing passing back.
Again, if you gift it to some, like a complete stranger, then the government's going to have a question. Like even the lawyers acting on the transaction would have a question, like why you're gifting it. Because most of the transactions that we get for gifts, that's usually to son, daughter, spouses, siblings, not to like a complete stranger.
But if you do have that kind of situation, and the person's planning to gift it, tell them to speak immediately to an accountant that's familiar with also foreign tax rules. Because let's say you could have a situation where you have a dad and they want to gift to two children, and both children are not Canadian citizens or PRs. What is the tax ramifications of them gifting it at that point, and then the foreigners owning the property and they want to sell it? So there's a lot of tax things here that may not make sense at all. Maybe instead of gifting to them, maybe dad just wants to sell it, get his capital gains exemption, and figure out as far as gifting money in the future. So before anybody does anything like that, they should always do heavy tax planning with an accountant.
Rental, so leases are exempt. So a foreigner can of course rent a property, because according to the definition of the purchase under the Act, a lease would be under the Act as well. So that's why it's clarified that leases are exempt. Okay. Transfer is done under the terms of trust created prior to January 1, 2023. If there was a trust agreement, but that has to be in place before the Act came into effect. Someone cannot draft a trust agreement now and do a transfer. So, transfer resulting from exercise of a security in trust or secured right by a secured creditor. But again, that secured right has to be before the Act came into effect. What this means is like a lender who has a mortgage on the property, they can still secure it, they can still proceed and do foreclosure or power of sale, but that has to be that trust must have been acquired before the Act came into place. So the last one, acquisition of residential property for the purposes of development, that again was introduced through the amendments that came into effect later on, because there was major pushback as to corporations or individuals that want to invest in residential real estate and develop it to make more housing. So that's why those corporations were also coming under this. They were also affected by this ban. There was a major pushback, and this was introduced. But again, it's very vague as to what is development purposes. So if someone reaches out to you and says, "Oh, I'm just an individual foreign buyer wants to buy and say I'm going to develop the property for myself," that's not development purposes, right? You can't assist them because that they can say it's for development purposes, and I'm going to live there myself. I'm going to develop and like sell it to a third party later on, but that's not development purposes. You have to be very, very careful if someone reaches out to you that way. So enforcement and penalties, we just mentioned that up to $10,000 of personal fines. So anyone who touches the file, real estate agents, mortgage brokers, lawyers, accountants, everyone can be held liable personally. And personal fines of up to $10,000. Each. Not total, each. If a corporation's helping, so the directors, officers, supervisors, agents, they can also be held personally liable, not just the corporation.
Who is finding this? Like CRA or RICO?
I think CMHC is...
On the agent side?
No, it's not RICO, it's the government. So it's
the government.
CMHC who's, I think, the supervising authority.
Got it.
Potential liability, so everyone, developers, sellers, assigners, lawyers, real estate agents, notaries, mortgage brokers, You must have seen in pre-construction also, like there's now a schedule,
Yeah.
a foreign buyer schedule. So even developers or builders, they are also careful now. They, even on assignments, they make sure that the assignee is submitting their PR card or Canadian passport before the assignment goes through. Same for any pre-construction purchase. They need a copy of the Canadian passport or PR card before you sign or when you sign.
Being pre-approved for a PR status, and I'm told the PR card is in the mail and it'll come in 4 to 6 weeks. No, we need physically in our hands today. We're going to enter into a deal to buy new construction today. We need that PR card in our hands today, not here's the pre-approval letter, it's a formality, it's coming.
Be careful with some of the builders and developers, because now if you read that schedule, some of the builders' schedule says that if at any point of time when you sign the agreement until you close the property, if you become a non-Canadian under the Act, then you're under default. So let's say if a Canadian citizen, permanent resident, they sign an agreement, they pay all those deposits, the property hasn't closed for 5 years, they decide to move out, they become a citizen of a different country, give up their citizenship here, they'll be considered at default under that agreement. They can lose all their deposits if they stop being a Canadian citizen or a permanent resident. So need to be careful with that, because some of the schedules of builders say that. Some just say that I'm not a Canadian, I'm a Canadian citizen or a permanent resident now, and I can go ahead with the purchase. But some of them say that if I stop being one, then I'm under default. Right, so potential conflict, like if you're acting for a buyer who's a foreign buyer, again, we've mentioned it many times already. Just be careful you have their IDs. You make sure that they are Canadian citizen, permanent resident, or they fall under one of the exemptions before you proceed with them. Because if they go and sign the agreement, and then they figure out they can't buy, they would be under a contractual obligation to purchase, but that they can't buy. The seller can still hold them liable for breaching their contract, even if they can't buy under foreign buyer ban. And just to be careful with that.
So they lose the deposit?
Lose the deposit, and the seller can still sue them for the. Again, steps to avoid knowingly assisting in willful blindness. Like we usually get them to sign, like of course the IDs, and then we usually have clients sign an affidavit saying that they are not exempt, that they're not prohibited under the Act. If you want one, we can share with you, of course, if you proceed going forward, if you want to have clients sign those, just for your file that you took that extra step to ensure that they're not foreign buyers. But I think for most of the buyers, you won't come across this. Only for buyers in which you are you have a doubt about, you can have that signed. Indemnities or termination rights that apply if purchaser Canadian undertake reasonable inquiries as to whether purchasers are non-Canadians. Again, indemnities is another document that we make them sign, that they'll indemnify us if their statement is untrue. You can have a similar one signed. We can share with you that as well. Right, sale of a property on conviction. So what happens if someone breaches it? So
they made it all the way through. They were a foreign buyer, they didn't disclose nothing, the deal is closed, they own the property, Justin Trudeau finds out, now what happens?
yeah, so the government can actually order sale of the property. It would be a court-ordered sale. They'll get a court order to sell the property. Any mortgages, if they've obtained, that would be paid off from the sale. Any profits won't be paid to the foreign buyer. So if on a court-ordered sale there's a profit, then that the government gets it, the foreign buyer doesn't. Okay, and again, they can also impose fines. They can impose further penalties on the foreign buyer, and again, they can use the sale proceeds to cover those fines and penalties. Okay, and you see any remaining amount to the Receiver General of Canada.
I wonder if they sell it at a loss, how they're going to collect that money with the foreigner not in Canada anymore. Interesting.
Yeah, not to forget the NRST, as mentioned, like someone who is not prohibited under the foreign buyer ban, someone who is exempt, might still be liable for the NRST, which is now 25% Ontario-wide, so anywhere in Ontario. That's just different brackets when different time periods when they were introduced, but now anybody who buys the property now in Ontario anywhere, that's 25% of the purchase price.
The municipalities, did you read anything about municipalities' plans to introduce their own, and did it go through? Have
I
you?
think Toronto's talking about it, right?
But they haven't, like, it's not there yet.
It's
like,
not there yet.
Yeah, but it'd be interesting if you buy in Toronto and they pass it through, then being double foreign buyer ban tax in Toronto and Ontario tax. So I'd be shocked if Toronto doesn't put it through.
What is it, 25 plus 25?
No, I'm saying if Toronto ends up passing something like that, and what the amount would be, and that would mean technically a foreign buyer would have to pay the Toronto tax and the Ontario tax plus the Toronto land transfer tax plus the Ontario, yeah. If.
Now, a quick refresh of NRST provisions. So who's subject to NRST? Individual who's not a Canadian citizen or a permanent resident, foreign corporation, taxable trustee. That's mostly similar to what the foreign buyer ban is, right? NRST applies to transfer of land that contains at least one and not more than 6 single-family residences. Is something, a property that's exempt from foreign buyer ban, but that's up to 3 dwellings, that can still be applicable, the NRST might still be applicable.
So different criteria for the ban to the NRST, plus if they do pay the NRST, they have a timeline of when they can apply for it back if they meet the criteria. If they never meet the criteria, they're not going to get that money back.
Yes, for the exemptions, that's nominee, refugee, spousal. I believe now it's the PR exemption for conveyances after March 29, 2022. It's only the permanent resident rebate that's available. If you become a PR within the next 4 years after the purchase, you can get that NRST back. The government give, but you have to become a permanent resident. Even if the delays are from IRCC, from the government, you still can't, right? You have to become a permanent resident within those 4 years. If you don't, you lose it, and you have to pay it upfront. You have to pay it, and then you get a rebate. You can't say that, oh, I already have my PR coming in the next year or so, so I won't pay it. So a foreign buyer would still have to pay it, but then they can apply for a rebate after they have the PR.
And it is from the APS date, not the closing date. Signing of the APS date.
I'm not really sure about that. I think it's the closing date.
Closing date.
I think it's the closing date. Yes.
I think it's closing as well.
Right, so that's it. Thank you. We're open for questions if you have any questions.
On this, and then any other matters that have come up of interest. I can tell you we're getting a lot of requests on status certificates. People still reviewing status certificates like no tomorrow, so people are buying condos, and usually Toronto, obviously.
All right, thanks, everyone.
Thank you for attending, everyone. And we'll see you all back soon for the next exciting topic. Stay tuned.